Chapter 9. Trusts arising by operation of law. Key exam issues. In writing an answer to an exam question involving trusts arising by operation of law, keep in mind the distinctions between resulting and constructive trusts. A resulting trust involves a reversionary interest when the equitable interest in property is not completely or effectively disposed of. It is based on the presumed intent of the settlor. Roman 2. A constructive trust is not a trust at all, but a remedial device based on principles of equity, usually imposed to cure wrongdoing or prevent unjust enrichment. Remember that the specialized purchase money resulting trust and the constructive trust may be used as remedies in non-trust situations as discussed in this chapter. 1. Watch for the following fact scenarios that may involve a resulting trust. A. The trust makes an incomplete disposition of trust assets. B. An express trust is unenforceable, e.g., the beneficiary is not properly designated. C. An otherwise valid express trust fails for illegality, impossibility, or impracticability. D. One person pays consideration to another for the conveyance of title to a third person, i.e., purchase money resulting trust. 2. Watch for the following fact situations that may implicate a constructive trust. A. The facts involve an unenforceable oral trust. B. There has been a breach of fiduciary duty. C. Title was acquired by some wrongful conduct, e.g., fraud, mistake, or conversion, etc. A. Introduction. 1. General nature 1000. Constructive and resulting trusts may arise out of situations in which an actual trust intention is present but fails. They are not created by expressions of that intention, but rather by operation of law. Thus, these trusts are implied by law or imposed by courts, rather than being the product of a settlor's intentional act. A. Constructive trusts 1001. Constructive trusts are remedial devices. They are imposed by courts in the exercise of their equitable powers to remedy wrongs or to avoid unjust enrichment. They arise out of diverse situations and in virtually all areas of the law. They may and often do arise in the context of trust law. B. Resulting trusts 1002. Resulting trusts are the reflection or implementation of reversionary interests found in situations frequently involving trust law, but they may also be found in situations that involve other areas of the law. 1. Note. One peculiar form of resulting trust, the purchase money resulting trust, has little to do with the primary subject of this summary, but is examined in some detail below in order to present a comprehensive treatment. 2. Failed trust or trust provision 1003. For present purposes, the most significant resulting trusts are those that are recognized by law on the basis of the legally inferred or implied intent of the transferor to retain equitable interests where the legal title has been transferred, accompanied by an expressed intention to create a trust, but where the transferor has failed, in whole or in part, to make a complete or effective disposition of all equitable or beneficial interests in the property. This incomplete disposition may result simply from the transferor's failure to create interests covering all possible rights and situations, i.e., provision is omitted or incomplete. Or it may arise because an actually expressed provision cannot be proved, e.g., proof is barred by the statute of frauds or statute of wills and therefore fails. Alternatively, it may arise because an otherwise properly created interest fails, e.g., purpose is illegal or beneficiary dies before date of transfer, or is rejected, e.g., intended beneficiary disclaims. 2. Statute of frauds, not applicable 1004. Recall that the statute of frauds does not apply to trusts arising by operation of law. As a matter of fact, both as originally formulated in 1676 and as enacted in most jurisdictions to date, there is a specific exception in the statute for trusts of real property created by operation of law. Hence, A. Constructive trusts 1005. A constructive trust may be founded entirely on oral evidence, provided the pleadings have alleged a cause of action and circumstances, e.g., unjust enrichment, under which such a remedy is appropriate. B. Resulting trusts 1006. Although a resulting trust is usually established without the use of parallel evidence, it may be established with the aid of such evidence as necessary. 3. Retroactivity, tracing, and accounting 1007. A decree establishing a constructive or resulting trust is normally retroactive to the date of the transferee's acquisition of title. The trustee is thus required to account for and pay over to the beneficiary or beneficiaries all profits realized from the property or its proceeds, and if the trustee has personally used or occupied the property, then for the fair value of such use or occupancy. 4. Duty to convey title 1008. In most instances, a resulting or constructive trust is basically a dry or passive trust, in which the trustee's sole duty is to convey the property. A. Constructive trusts 1009. A court decree establishing a constructive trust simply directs the title holder to make the appropriate transfer or empowers the beneficiary to demand the transfer. Where the constructive trust is to implement an intended express trust that requires more than placing title in an appropriate transfer, e.g., to carry out the purposes of a secret trust that involved an intended but unenforceable express trust for X for life, remainder to X's issue, it is likely that the directed conveyance will be to another as trustee to carry out the terms of the intended trust. Scott on Trusts 465, 465-1. B. Resulting trusts 1010. When a resulting trust is recognized and other provisions of an incomplete express trust have been fully implemented, the trustee's only remaining duties are passive, involving a conveyance to the grantor or other reversionary successor in interest. Where terms of an express trust remain to be implemented, the trustee may continue to have active duties to other beneficiaries plus resulting trust obligations, including active duties to distribute excess earnings, and sometimes even unneeded portions of corpus, or to preserve, manage, and hold trust property for future distribution to the grantor or his successors. B. Resulting trusts 1. General nature of resulting trust 1011. The best way to understand the general nature of a resulting trust, or of a resulting trust interest, is to consider it equity's way of recognizing an equitable reversionary interest, e.g., an interest remaining in a prior owner who, in making a transfer, made what turned out to be an incomplete disposition of the beneficial, i.e., equitable ownership. Thus, a resulting trust arises where the transferor, in conveying the property, did not intend for the person receiving legal title to have the beneficial interests, or at least she is legally presumed not to have so intended and failed to make a complete or effective disposition of the beneficial interests in that property. Rest. 3D7. 8. Leaving aside for the moment the purchase money resulting trust infra, 1D21 at sec. There are 3 general types of situations that give rise to resulting trusts, see below. Exam tip. Be sure you understand the difference between a resulting trust and an express trust. A resulting trust is based on the legally presumed intention of the transferor, while an express trust involves the transferor's actual intention. A. Failure to express intent as to some or all beneficial interests, 1012. In some resulting trust situations, the transferor did not express, presumably by oversight, an intention with respect to some or all of the beneficial interests in the property, i.e., she did not make a complete disposition of the equitable interests. 1. Excessive trust res 1013. Where the amount of property transferred to the trust proves, whether temporarily or permanently, excessive for the purposes of the trust, and no disposition of the surplus is indicated, courts may infer that the settlor did not intend to make a disposition of the surplus or to allow the trustee to retain it, but rather intended to retain it herself by way of resulting trust for her benefit or that of her successors in interest. Example: transferor conveys Blackacre to transferee in trust to pay such amounts of income as are necessary for the support of beneficiary, and on beneficiary's death to convey Blackacre to charity. The income from Blackacre significantly exceeds the amount reasonably appropriate for beneficiary's support. If the court infers that beneficiary is not to receive all income, and that the surplus is not to be accumulated for future needs or for future distribution to charity, then the right to the excess income has not been disposed of apparently, it was overlooked, and is payable to transferor or her successors by resulting trust. 2. Unanticipated circumstances for which no interest expressed 1E14, where expressed interests are provided covering some, but not all circumstances, others apparently having been overlooked. The undisposed of interests are held upon resulting trust for the transferor or her successors. Example: transferor bequeaths to transferee in trust to pay the income to beneficiary for life, and on beneficiary's death to transfer the principal to beneficiary's then living issue. Beneficiary dies without having had issue. Because no provision has been made and no interest has been created for the circumstances that have materialized, the property reverts, i.e., transferee holds upon resulting trust for transferor, her residuary beneficiaries, or, if none, or if the trust was itself a residuary trust, her heirs at law. B. Expressed trust unenforceable 1015. Where the transferor has sought to dispose of the equitable interests by express trust, but that trust is not expressed in a form that permits it to be enforced, i.e., the transfer is not effective, a resulting trust may arise. 1. Effect where no appropriate remedy 1016. If, under the circumstances, a constructive trust is not appropriate, and the terms of the transfer are such that the transferee is clearly not allowed to retain the property, hence, no need for a restitution remedy, then the beneficial interest has not been effectively disposed of, but remains as a reversion in the transferor or her successors by way of resulting trust. Example: transferor bequeaths or devises to transferee as trustee, but specifies no beneficiaries or other trust terms, or the will leaves to transferee in trust upon such terms as I have or may communicate to transferee during my lifetime. Assuming no special circumstances exist such as actual fraud requiring a constructive trust for transferor's estate or others, it is clear on the face of the instrument that transferee takes in trust, but under the general rule today, the terms of the trust cannot be proved and cannot be carried out. Transferee holds on resulting trust for transferor's estate for the benefit of her residuary beneficiaries or, if none, her heirs at law, i.e., an equitable reversion remained in transferor's estate. C. Express trust fails for other reasons 1017. Where the intended express trust fails, in whole or in part, for other reasons, the interests that fail assuming the gaps are not to be filled by construction, allowing the transferee or other beneficiaries to take by implication or acceleration remain in the transferor, so that the property is held upon resulting trust for the transferor or her successors. 1. Failure of interest for illegality, impossibility, or impracticability 1018. Such a situation may arise because it is immediately or subsequently discovered that some or all of the beneficial interests cannot be carried out, because it would be illegal, impossible, or impracticable to do so. Example: transferor, a chef, bequeaths her residuary estate to transferee in trust to provide scholarship funds for the benefit of the outstanding students of my alma mater, the National Culinary Institute. On transferor's death, the National Culinary Institute is defunct. The court holds that the Cypres doctrine is inapplicable, and the charitable trust fails. Transferee now holds the residuary estate upon a resulting trust for transferor or her successors in interest. Example: transferor bequeaths to transferee in trust for the benefit of beneficiary until beneficiary reaches age 25. The principal and any unexpended income then to be paid over to beneficiary. Beneficiary, however, predeceases transferor, and all of beneficiary's interests lapse and others are not substituted by antilapse statute. See Will's summary. Had beneficiary outlived transferor, there would have been a complete disposition because, by normal rules of construction, beneficiary's future right to the property is indefeasibly vested, so that even her death before attaining age 25 would not cause her interest to fail, rendering the disposition incomplete. Because here beneficiary predeceased transferor, the intended interest fails and the equitable rights in the property are not effectively disposed of. Transferee holds upon resulting trust for transferor's estate, i.e., for her residuary beneficiaries or heirs at law. 2. Failure of interest due to disclaimer 1019. Sometimes a transfer is altogether complete on its face, but one or more of the equitable interests are renounced by the intended beneficiary. Often the gaps in these situations are filled by statute, by construction, or by acceleration of a remainder interest, e.g., is devises to L for life, remainder to R. On disclaimer by L, the remainder to R will accelerate, as if L had died. But if no gap-filling provision applies, the void created by the disclaimer leaves a part of the equitable interests in the property undisposed of, i.e., there is a reversionary interest, and the trustee holds in part at least upon a resulting trust for the transferor or her successors in interest. 2. Consequences of such cases 1E20. In all of these cases, a resulting trust arises by operation of law with respect to all or some equitable interests in the property, either some quantity or portion or some present or future interest, because the deed or will failed to make complete, effective disposition of the property. In other words, some interests remain in the grantor or her estate, after the court has considered the various possibilities for filling in the gaps or deficiencies by construction of the instrument, and has also considered any alleged grounds for remedial action in the form of a constructive trust, either in favor of the intended beneficiaries or to effect restitution to the transferor or her successors in interest. The recognition and enforcement of resulting trust interests also assumes that the failure to make effective disposition was not the result of any illegality of a type that leaves the transferor with unclean hands, such that a court of equity will refuse to intervene. C. Purchase money resulting trusts. 1. Development and status of doctrine. A. Background 1E21. At early common law, courts adopted a strong presumption against a gift, so that if a person paid the consideration for the property, but had title conveyed to another, the use beneficial enjoyment was deemed to go to the person who paid the consideration. Also, if a person gratuitously deeded property directly to another with no mention of the beneficial use, the use remained in the grantor. B. Early implications, I-1E22. Thus, after the statute of uses which operated to convert many uses into legal interests, one who paid consideration for a transfer of land became the legal owner, and one who made a gratuitous transfer of land remained the legal owner, via the statute's execution of the use. Example: payer paid money to seller for the purchase of Blackacre, but had title conveyed to transferee. The use resulted in favor of payer, and was converted by the statute into full legal title in payer. Example: donor gratuitously conveyed land to transferee, reciting no use in transferee or in another. Here, a use arose by operation of law, i.e., resulted in favor of donor. Thus, application of the statute of uses would result in no interest whatsoever passing to the intended grantee. Armstrong v. Woolsey, 95 Eng. Rep. 662 1755. C. Modern status of doctrine, 1D23. The law today has evolved into a somewhat different body of doctrine in some significant respects. 1. Direct gratuitous conveyance gift 1D24. Today, a gratuitous voluntary conveyance to another is presumed to be an absolute gift to the grantee, and there is no resulting trust causing retention of title by the grantor. Graves v. Graves, 29 NH, 129 854. 2. Purchase price paid by one person who directs title to be in another resulting trust 1D25. In the purchase money situation described above, where one person pays consideration to another for the conveyance of title to a third person, The old law prevails in most jurisdictions. The early presumption against a gift has carried over into the modern doctrine of purchase money resulting trusts in favor of the one who paid the consideration. See below. A. Minority view 1D26. A few jurisdictions, usually by statute, have flatly repudiated the doctrine of purchase money resulting trusts. In such states, the mere fact that the purchase price was paid by one person and title was conveyed to another is not enough to raise a presumption that the grantee holds on resulting trust, rather than beneficially. Rather, such a conveyance is presumed to be a gift. MAL. Annotation. Right of creditors in respect of property gratuitously conveyed or transferred to a third person for alleged benefit of debtor. 147 ALR. 160 1943. 2. Statement of doctrine under modern law resulting trust presumed 10 at 71, where the purchase price for property is paid by one person, but, at his direction, title is transferred by the seller to another, and there is no close family relationship between payer and grantee of a type that gives rise to an exception. See infra. 141. It is presumed that no gift was intended. There is instead a rebuttable presumption that the payer intended the grantee to hold legal title as trustee upon a resulting trust on behalf of the payer. Howe v. Howe, 85 NE, 945 Mass. 1908, Rest. 3D9. Example. Payer pays the purchase price for Blackacre. At payer's direction, the seller conveys title to transferee, who is unrelated to payer. There is a rebuttable presumption that transferee holds legal title as trustee upon a resulting trust for payer. It is presumed that payer did not intend to make a gift to transferee in this situation. A. Minority view presumption reversed 1E28. Reasoning that because the payer's gratuitous deed directly to the transferee would presumptively be a gift, it should make no difference that the payer pays another to convey to the transferee. A few courts presume a gift in this situation as well. Even under this view, however, if the transferee had acted fraudulently in making an oral promise to hold title on behalf of the payer, a constructive trust would be imposed in favor of the payer. Duncan v. Laurie, 249 AD, 831 1937. 3. Operation of purchase money resulting trust doctrine. A. Payment, nature, and timing of consideration. 1. Effect of deed recitals 1E29. Recitals in the contract of sale or deed as to who paid the consideration, or even as to the amount of consideration paid, are not conclusive. Under a generally recognized exception to the para. Evidence rule, extrinsic evidence is admissible to show the source and nature of consideration for a transfer. See evidence summary. 2. Form of consideration 1030. The consideration given by the payer can be of any type: money, other property, or even services, or a promise to pay. 3. Consideration paid after deed 1031. However, a person's payment of some or all of the purchase price, with no obligation to do so, after the transfer of title does not create a presumption of resulting trust. Saulnier v. Saulnier, 103 NE2D 225 Mass. 1952. Rest. 2D 457. 4. Pro rata resulting trust 1032. To invoke the purchase money resulting trust doctrine, the payer need not supply the entire purchase price. If he pays part of the consideration, but has title conveyed solely to the other person, a pro rata resulting trust is presumed. Rest. 3D9 CMT. D. Example. The price for Blackacre is $100,000. Payer pays the seller $50,000, while transferee supplies the balance. If title is taken in transferee's name only, it is presumed that transferee holds an undivided 1/2 interest on resulting trust for payer. Mershat v. Mershat, 117 NE2D 868 IL. 1954. A. Rebutting the presumption 1033. Parallel evidence may be introduced, not only to rebut the presumption of a resulting trust, but also to show that a different proportion was intended to be held for the payer. Parallel evidence may also be used to show that the parties intended to divide the property not proportionately, but into successive estates, e.g., life estate in the transferee, remainder in the payer. Note: the natural object of the bounty exception, see infra 1941-1946 applies here also. B. Rebutting the presumption 1034. The presumption that the transferee holds title on behalf of the person who paid for the property is always rebuttable by proof that the payer did not intend such a trust. Rest. 3D9. 1. Payments made as loan to transferee 11,035. No resulting trust arises if the payer advanced the monies as a loan to the transferee. Because the transferee has to repay the loan, the funds were really provided by the transferee, and there is no basis for presuming a resulting trust. Rest. 3D9 CMT. E. Example: if payer agreed to loan transferee $100,000 with which to purchase Blackacre, and payer or transferee used these funds accordingly regardless of whether payer delivered the funds directly to the seller or to transferee, who then delivered the funds to the seller, there is no resulting trust in payer. The purchase price was paid by or on behalf of transferee, even though by loan from payer. Compare: had payer loaned money to transferee to purchase Blackacre, and title been placed in payer's name as security for repayment, payer would have held on resulting trust in favor of transferee. Borrowed consideration was furnished by transferee for transfer to payer, and payer's lien precludes transferee from forcing the transfer to him before repayment of the loan. Fox v. Shanley, 109A, 249 Con. 1920. 2. Evidence showing intent to make gift 1036. The presumption of resulting trust may be rebutted by evidence showing that the payer intended the transferee to take beneficially, i.e., that the payer intended to make a gift to the transferee. A. Parallel evidence 1037. The proof to rebut the presumption may be entirely oral, even though title to real property is involved. This is because the statute of frauds does not apply to the creation of trusts arising by operation of law, see above, or to the rebuttal of such trusts. 3. Oral agreement to hold in trust for third person 1038. What if evidence rebutting the resulting trust presumption would establish an oral trust for another in violation of the statute of frauds? Example: payer pays the seller and directs the deed be made in transferee's name. Transferee is unrelated to payer, relying on transferee's oral promise to hold the land in trust for third party, which would be unenforceable, of course, as an express trust. A. Result: if the payer claims a resulting trust, the transferee can rebut that presumption by showing the oral agreement to hold for the third party. B. Distinguish constructive trust 1039. But the third party cannot enforce the express trust because of the statute, although the transferee may voluntarily perform its C supra 325 upon proper grounds, fraud, etc. If the transferee refuses to perform, the third party should be the beneficiary of a constructive trust. Otherwise, however, rather than allow the transferee to be unjustly enriched, some courts may impose a constructive trust for the payer, see infra 1947 et sec. 4. Close family relationship 1040. The presumed resulting trust for the payer in these various situations may be rebutted by showing a close family relationship, which triggers a counter-presumption in favor of a gift to the transferee. This situation is generally treated by courts not as a rebuttal of the presumption of a resulting trust, but as an exception to the presumption. See below. Exam tip: if you encounter an exam question in which a person obtains legal title from the seller, but another person paid the consideration, remember that the presumption is that the transferee holds title on a resulting trust for the payer. However, this presumption is rebutted if I. the payer loaned the purchase price to the transferee, who is thereby indebted to, but does not hold the property for the payer, Roman 2, the payer intended to make a gift of the property to the transferee. Roman 3, the payer and transferee entered into an oral agreement that the transferee was to hold the property in trust for a third party. Or Roman 4, the transferee is a natural object of the payer's bounty treated as an exception to the presumption rather than a rebuttal. See infra. C. Exception transferee is close relative 1941. The most important limitation on the operation of the purchase money resulting trust doctrine is that it does not apply, i.e., that there is no presumption of resulting trust where title is transferred by the seller at the payer's request to a natural object of the bounty of the payer. In such cases, there is a presumption of gift. Rest. 3D 92. 1. Natural objects of payer's bounty. 1042. For purposes of establishing a presumptive gift, the following transferees are generally held to be natural objects of the payer's bounty. A. Children, grandchildren 1943. The payer's children, grandchildren, or other descendants, and persons to whom the payer stands in loco parentis, are deemed the natural objects of the payer's bounty. Ultramano v. Swan, 20 Cal. 2D 622 1942. B. Spouse 1044. The payer's wife is a natural object of the payer's bounty, but authorities are split on whether this exception applies as well to a payer's husband, some cases assuming no gift, but rather that the transfer was made in order to have the husband manage the property or was the result of his domination. Rem v. Rem. 32 Pa. D. and C. 193 1938. The modern trend is to presume gifts on a gender-neutral basis. Mims v. Mims. 286 SE2D 779 NC. 1982. Rest. 3D 92 and CMT. B. C. Distinguish other relatives and relationships 1945. But the presumption of a gift has often been held not to apply in the case of a transfer to parents, siblings, in-laws, or other more remote relatives. Hence, a resulting trust is presumed. Gowell v. Twitchell, 28 NE2D 531 Mass. 1940. Even here, a gift may be presumed if parents are involved, or if, for want of closer relatives, the related transferee would stand in direct line of intestate succession. See Rest. 3D 9 CMT. B. Gift may even be presumed where transfer made to spouse of payer's descendant, payer's fiancé, or to person with whom payer has cohabited for significant period of time. Exam tip. Under the close relative exception to the purchase money resulting trust doctrine, a gift, not a trust, is presumed from the following relationships. Parent supplies consideration. Title taken in child's name. Grandparent supplies consideration. Title taken in grandchild's name. And husband supplies consideration. Title taken in wife's name, although under the modern trend, the gender of the parties would not matter. The normal presumption of a trust generally applies where the person furnishing the consideration is the uncle, aunt, brother, sister, child, or grandchild of the person receiving title. 2. Gift presumption rebuttable 1046. The exception merely reverses the presumption, but the presumption of a gift may also be rebutted by proof of contrary intention, which would establish a resulting trust. Nolan v. American Telephone and Telegraph Co., 61 NE2D 876 IL. 1945. Rest. 3D 9 CMT. C. It is not objectionable under the statute of frauds in this situation that the oral evidence establishes an oral trust for the payer, for the evidence is offered not to establish an express trust, but to show the absence of a gift, and to have a resulting trust arise by operation of law. D. Constructive trusts. 1. Remedial device, not really a trust 1947. A constructive trust is not really a trust at all. Rest. 3D1 like a resulting trust. It arises by operation of law, but, quite differently, it serves as an equitable remedy to redress wrongful conduct or prevent unjust enrichment. It is imposed whenever a court of equity is convinced that the person who acquired title to the property is under an equitable duty to convey it to another, because the acquisition was by fraud, duress, mistake, etc., or because in certain appropriate circumstances the holder of title would be unjustly enriched if he were permitted to retain the property. In essence, a constructive trust is not designed to effectuate an express trust intention, but rather is to serve as a remedial device to prevent injustice. Keep in mind that despite the term constructive trust, a constructive trust is not really a trust at all, but rather is an equitable remedy imposed to redress wrongful conduct or prevent unjust enrichment. Usually, the constructive trustee's only duty is to convey the property to the person who would have owned it, but for the wrongful conduct. 2. When oral trust unenforceable 148. The constructive trust remedy is frequently applied when property was transferred by one person to another on an intended trust, but the trust is unenforceable. Usually, in such cases the express trust is not allowed because of lack of formalities, e.g., oral promise to hold in trust made with respect to land or assets passing by will. Then, if the trustee refuses to carry out the oral trust agreement, courts of equity will, in appropriate circumstances, impose a constructive trust. The rationale when a constructive trust is imposed is that it would encourage and reward wrongdoing or constitute unjust enrichment to permit the trustee to retain the property outright. See discussion of constructive trusts arising from breach of unenforceable oral agreements to create express trusts with respect to land or testamentary gifts, Supra 327, 346, 358, 366. 3. As remedy for breach of fiduciary duty 149. A constructive trust may also be imposed when property is obtained by one person through breach of a fiduciary duty owed to another. Example: a trustee absconds with trust funds and uses the money to buy a house for himself. A constructive trust may be imposed on the house in favor of the beneficiaries whose funds were taken. See Infra 1058 for discussion of tracing. A. Other situations 1050. This is by no means limited to the wrongdoing of trustees. Constructive trusts may be imposed whenever fiduciary duties are owed by one person to another, e.g., an attorney to a client, a guardian to a ward, an executor or administrator to the beneficiaries of a decedent's estate, the director of a corporation to the corporation or its shareholders. See Corporation's summary for discussion of duty of a director not to appropriate for himself a corporate opportunity and other such breaches. 4. As remedy in non-trust situations 1051. The constructive trust remedy is also available as a remedy to prevent unjust enrichment and to rectify wrongs in non-trust situations. The following are the most frequently encountered applications. A. Fraud 1052. Suppose the transferee defrauds the transferor into transferring title and possession of Blackacre to the transferee by falsely representing that she will make valuable improvements on the property, which will benefit other property owned by the transferor. In transferring the property to the transferee, the transferor in no way intended to retain any interest, and the transferee certainly did not intend to assume any fiduciary duties. Nevertheless, upon discovery of the fraud, the transferor can sue the transferee to impose a constructive trust upon the wrongfully obtained profits and property or its proceeds if it has been sold, i.e., the law will impose a fiduciary status with an obligation to reconvey title or proceeds and profits, even though this was not the actual intention of the parties. 1. Actual fraud 1053. In such situations, the constructive trust remedy is generally appropriate only where the transferee is guilty of actual fraud. One who makes a promise never intending to perform it is guilty of fraud, and if this can be shown, a constructive trust would be proper. However, a mere broken promise is normally not enough, although other remedies may be available even where a constructive trust is not. 2. Abuse of fiduciary or confidential relationship 1054. If the promisor-transferee stands in a fiduciary or confidential relationship to the party from whom she acquired the property, most courts will then impose a constructive trust for breach of promise without actual fraud, the breach being a violation of the transferee's fiduciary duty and hence, as some courts would put it, a constructive fraud. Likewise, a transferee who obtains property from another by mistake innocent or otherwise holds on constructive trust for the transfer. Example: grantor conveys 2 tracts of land to grantee, while intending to convey only one. Grantee holds the second tract on constructive trust for grantor, whether grantee knew of the mistake or not. See Remedies Summary. C. Other Situations 1056. Imposition of a constructive trust is often appropriate where a transferee obtained title to property by conversion, theft, or duress, or where a transferee acquired title as beneficiary under the will of a decedent whom he murdered, or as surviving joint tenant where he murdered the other joint tenants. A constructive trust may even be imposed on an inheritance where an heir, or by the better view, another person wrongfully prevented the decedent from making a will. Pope v. Garrett, 211 SW2D 559 text, 1948. Compare Rogers v. Rogers, 63 NY2D 582 1984. Common situations where constructive trust imposed. When a fiduciary breaches his duty to another. When the transferee obtains title to the property by fraud, mistake, conversion, theft, duress, or homicide. Sometimes, when an express trust fails due to lack of formalities, e.g., oral trust. See Supra, 327 346, 358 366. 5. Effect of transfer to a third person 1057. If the wrongdoer sells the wrongfully obtained property to an innocent purchaser who purchases in good faith and for value, this will cut off the wronged party's right to have a constructive trust imposed with respect to that particular property. This is because, under the general rule, a transfer of legal title to a bona fide purchaser cuts off all hidden equities. A. May reach proceeds 1058. However, a constructive trust may be imposed upon the proceeds of the sale and profits in the hands of the wrongdoer under the tracing doctrine. Example: trustee misappropriated trust funds of which he was trustee and used them to purchase a television and stereo for himself. Later, trustee sells the television and stereo to BFP, a good faith purchaser for value, and deposits the funds in a bank account. The trust beneficiaries or a successor trustee can have a constructive trust imposed on the funds and interest thereon in the bank account. B. Not a bona fide purchaser 1059. If, however, the transferee did not give value, i.e., was a donee, or if at the time of purchase he knew of the source of the funds used by the wrongdoer to acquire the items in question, or in some other way was on notice concerning the goods, he is not a bona fide purchaser and is not entitled to retain the goods because he does not cut off the equities of the beneficiaries. In this case, a constructive trust can be imposed upon the items in his hands. The beneficiary then will have a choice of either of 2 possible constructive trust remedies to pursue: against trustee for the proceeds or against BFP with respect to the television and stereo. Reversionary interest recognized where transferor fails to make a complete or effective disposition of beneficial interests in property. Settler or his successors in interest. Rebuttable presumption against a gift, where one person pays another the purchase price for transfer of title to a third person. But presumption of gift if third person is natural object of payer's bounty. One who pays the purchase price. Remedial device imposed to cure wrongdoing or prevent unjust enrichment. Intended beneficiary or settler.